Hello and welcome to Topic 9, Lecture 2. And in this lecture, we're going to be learning about court personnel. So, what are we going to be covering in this lecture? Well, we're going to learn about the court personnel, in particular, the prosecutors and the defense attorneys. And so, we're going to learn about the different types of prosecutors, what the duties of the prosecutors are, and we're going to be learning about a concept of professional or prosecutorial discretion. We're also going to be learning about the defense attorneys, the different types, the duties, and the different ways that defense attorneys are assigned to the criminally accused, since we have a constitutional right to counsel that comes from the Sixth Amendment. You're responsible for reading about the other court personnel in the textbook, including information about judges. So let's go ahead and get started. So, regardless of the type of criminal court, there are certain players that fulfill specific functions. There are criminal prosecutors, oftentimes known as district attorneys or DAs. There are criminal defense attorneys, judges, and also other personnel, such as the court clerk, bailiff, or court reporters. Now, you'll recall from earlier in the semester that we learned about the courtroom work group and how they have certain values and norms, in particular, trying to get a criminal case through the system as quickly as possible. And so this courtroom personnel are the individuals that make up that courtroom work group. There are two types of prosecutors in the United States. One is for the federal prosecution and the other is for state prosecutions. And so federal prosecutors are known as United States attorneys, okay, or U.S. attorneys. And there are 93 U.S. attorneys within the United States. These are political appointees, and so that when they are nominated by the President of the United States, and then they are confirmed by the Senate. There's no constitutional obligation that U.S. attorneys resign at the end of a president's term, but that's generally what happens. Generally, U.S. attorneys, because they are political appointees, they will tender their resignation at the end of a president's term, and then the new president will decide whether they stay on in their job or whether they will be replaced. And the current president, President Biden, has replaced many of the Trump appointed U.S. attorneys. At the state level, at least in Wisconsin, our state prosecutors are referred to as district attorneys. And that's common in many states. And the district attorneys represent counties. And so, for example, we have the Milwaukee County DA, who is John Chisholm. He's been in office for quite some time, since 2007. The Waukesha County DA is Susan Opper. She's been in office since 2015, and she's actually announced that she's retiring in 2024. She's had a long career, she said, but also she says it's becoming difficult to basically manage and govern over the county district attorney's office due to lack of funding and the salary of the assistant district attorneys, that it's hard to bring in new talent. And so she sort of talked about that was why she's retiring. And in Washington County, Mark Benson is the district attorney, and he's been in office since 2010. That district attorneys are not appointed by the governor of the state, but they are an elected position. And so they are elected every 4 years. They serve a four-year term, and they are subject to reelection. But you can tell, since John Chisholm's been in office since 2007, Mark Benson since 2010, the chances of getting reelected are relatively high. One district attorney has received a lot of attention as of late, and that is the district attorney for the borough of Manhattan in New York City, Alvin Bragg. As most of you are aware, Alvin Bragg was the prosecutor. It is the prosecutor in charge of investigating a scheme by former President Donald Trump to cover up potential sex scandal during the 2016 presidential campaign. And so he's been in the news recently because his office was in charge of that investigation and then ultimately ended up charging Donald Trump with 34 felony charges, which we'll talk about in one moment. And so that's one of the things that prosecutors do. If they think that there is a crime going on in their jurisdiction, they will begin investigating it. And Alvin Bragg thought that there was criminal actions that were revolving around these hush money payments to the porn star Stormy Daniels. And so he and his team of assistant prosecutors began investigating that. As a part of that investigation, they brought in a grand jury. They presented evidence to a grand jury, and the grand jury then decided to issue an indictment or charges against the former president. And so prosecutors, that's a big famous example of of that investigatory power. But as you'll be learning in the book Locked Up, that is a large part of what prosecutors do. They investigate crimes. Oftentimes those crimes are just presented to them through law enforcement, through people who have been arrested. But they investigate violations of the law to decide whether or not charges or formal charges should be filed. Okay. And so they investigate violations of the law, and then they decide whether or not they're actually going to pursue the case, whether they're actually going to charge the individual with the crime. And so as we know that prosecutors have prosecutorial discretion, okay, which we'll be talking about more in a moment. After other duties of the prosecutor are to prepare for trial. And so that, as we know, the former president pled not guilty to the 30 felony charges for falsifying business records. And so both sides are beginning to prepare for trial. They will interview witnesses in the criminal case. They'll look at evidence. Both sides will begin that preparation for trial. And then if the case actually goes to trial, and it will be some time before we know whether or not this case actually goes to trial, the prosecutor, or at least somebody from the prosecutor's office, will be the one who tries the criminal case. In the example of Alvin Bragg was at the helm in terms of deciding whether or not to charge Donald Trump with a crime, but it's his assistants who will actually be doing the work to prepare for trial. So his assistant district attorneys in his office. If a plea bargain happens, doubtful, but who knows what's going to happen in the Trump case, that the district attorney engages in plea bargaining negotiations, and if it goes to trial and the individual is convicted, or if there's a plea bargain where somebody pleads guilty, then prosecutors will recommend a sentence to the judge, and it's the judge who does the sentencing. And then finally, if there is an appeal in the case from the criminally convicted, then the prosecutor's office would represent the state in the appeal. And so that's an overview of some of the duties of the prosecutor. So as we learned earlier in the semester, and as you'll be digging into more deeply in the book Locked In, that we know that not all who get arrested are actually charged with a crime, okay? That we know that prosecutors have broad discretion over case rejection or dismissal, okay? And we know that that's referred to as nolli prosequi. In other words, that prosecutors must just oftentimes conclude that they're unwilling to pursue charges against somebody. Now you might be saying, look, is that fair? Like, why does a prosecutor not charge? That they have this discretion, shouldn't there be some oversight? I mean, there's oversight when prosecutors decide to charge, right? In the preliminary hearing, and then also with a grand jury. But is there any oversight? Is there any check against the prosecutor abusing their power, not for charging somebody, but abusing their power in deciding not to charge? But as it says there, that the Supreme Court has actually considered this issue, this question, and they've concluded that district attorneys have broad discretion in terms of deciding whether or not to pursue a case. So decisions not to pursue are very rarely, if ever, reviewed by the court. So it's a huge power that prosecutors have, the power to not prosecute. Although, as you're going to see in Locked In, that it's a huge power that prosecutors have to prosecute. And even though we have checks in place, that those checks oftentimes don't often stop a runaway prosecutor who wants to charge somebody and charge them with a very, very serious crime. Those who study the actions of prosecutors have come up with 4 factors that seem to influence prosecutors' decision about whether or not they should charge somebody with a crime. The 4 factors are system factors, case factors, disposition factors, and political factors, okay? So in the following slides, we're going to go into each of these factors in a little bit more detail, and then we're going to think about these 4 factors and apply them to the district attorney's Bragg's decision to charge former President Trump with crimes. There's been a lot of backlash, both on the right and in the left, in terms of the decision to actually charge Trump with these felonies. And so we'll look and apply these factors, asking ourselves, what did Bragg take into consideration as he was thinking about whether or not to charge Trump with crimes? One factor that prosecutors take into consideration is what's known as system factors. And what system factors are is that there are certain features of the court system that may make it so that a prosecutor doesn't really want to pursue charges, okay? So this isn't necessarily about the case-specific factors, but this is more looking at the court system in general. So some examples of system factors are just the cost, okay? It costs a lot of money to go to trial, okay? And that's in part why there is a lot of pressure to pursue plea agreements, because it's expensive for prosecutors, it's expensive for the state, it's also expensive for the defense team as well. And so, sometimes prosecutors just say, look, how long is this case going to take? How much is that going to cost? And is that a worthy expenditure of state resources? You might look at how many courts are on the docket and how much backlog there is. So, we know that the wheels of justice move slowly, but when you have a huge court backlog, it may mean that it's going to take a long time for this case to get through the system. So that might be another factor. And also that if you are going to pursue charges, you know that you have to assume that the other side is going to plead not guilty and you got to prep for trial. So a prosecutor might ask themselves, you know what? Maybe I should spend my time doing something different, spending my time as a district attorney on more serious offenses or more prevalent offenses that are taking place within the community. So those are some of the system factors that prosecutors can take into consideration. The second factors are what are known as case factors. And these factors that district attorneys take into consideration have to do with the specific features of the case, okay? And because of the specific features of the case, they may decide to not pursue charges, okay? And so some examples of case factors: strength of evidence, okay? And so since if you charge somebody, they could go to trial, and you've got to win at trial, right? Thinks the prosecutor. And so that they look at the evidence, and let's say that you're pursuing charges against somebody for murder, and you look at the evidence, and there's not a lot of forensic evidence, right? There aren't fingerprints, there aren't blood, DNA, that there's no surveillance tape. You might say, we think this person is guilty of murder, but we don't have enough to make the case at trial, so we're not going to pursue charges. That it could also be a case factor could be the willingness of the suspect to cooperate, okay? If you know that the suspect's going to cooperate and you have a sense that they are going to plead guilty, you might be willing to charge them. Because if they're willing to cooperate, it's going to get through the system easier, and you could charge and get a plea of guilty and not expend as many resources, okay? But if you feel like there's no way in heckadoodle that the suspect is going to cooperate, you might take that in consideration when thinking about a charge. And that the victim's relationship to the accused, right? And so that if a person is accused of killing a family member, that are the victims of that murder your relatives? Are they going to come and testify? If you beat somebody and they're your friend, or assault them, are they going to come and testify? And so all of these can be taken into consideration. Okay. That doesn't mean that a prosecutor's not going to pursue charges just because of a father who kills their son and wife, as was the case in the Murdoch case, right? But they take that into consideration. And also, if it's a really serious case, of course they're going to pursue, even if they feel like the witness is not going to cooperate, because a prosecutor can get in trouble for not pursuing a really egregious crime, such as like first-degree intentional homicide. So these factors can cut both ways. Your textbook talks about disposition factors that can be taken into consideration. Might look at the aspects of the case a prosecutor might, and they might say, look, there's a better way of handling this case than charging and trying. And so that they could work with, a prosecutor could work with a defense attorney, and they could say, look, that we're willing to engage in a pretrial diversion. And what that means is that we will basically agree to expunge charges or to waive charges if a defendant does certain things, right? And so they might refer a defendant to an agency, like for a drug addiction or for job training or for anger management. And if they go through the requirements from the agency, then the charges will be dropped. And so that can be a reason why prosecutors, it's sort of charging, but not really, because they are hopeful that this will be taken care of, that it will be disposed of in a way that doesn't involve a trial and a lengthy plea agreement. And that brings us to the last factor, which is political factors. When it comes to state prosecutor, and the vast majority of prosecutors are state prosecutors, the vast majority of them are elected, that they're ultimately accountable to the people, and that the prosecutors can take that into consideration that when they're exercising their discretion. And so they might pursue charges because they might feel that that's what the people who elected them want them to do. Or that they could say, ooh, if I pursue charges against this people, I might get in trouble and not get reelected. So you might want to back off from a case, right? Let's say that you have a son of a wealthy donor, and that prosecutors run for elected office and they get donations to their campaign just like any other person running for office. Well, let's say, oh, the son got in trouble with drunk driving or some sort of crime. Ooh, if I pursue this case, there goes my campaign donation, right? So, hopefully prosecutors wouldn't do that, but it's a good example of the political factors that might be taken into consideration. In other words, they may feel pressure to pursue a case or not pursue a case based on an upcoming election, or if you were recently elected, the sense that you have that the voters, this is why they elected you. They wanted you to be harder on crime, or like not pursue drug cases or whatever it may be. And you might feel like you need to be beholden to the will of the people that elected you. So this brings us back to DA Bragg and his decision to charge former President Trump with 34 felony charges of falsifying business records. So what factors do you think Bragg considered when deciding to pursue charges against Trump? What do you think he kept in mind when he was thinking about, well, should I pursue these charges or should I not pursue these charges? Well, obviously he probably thought a lot about system factors, that this is going to be a time-consuming and costly endeavor. And so clearly he must have thought deep and long about whether or not pursuing these charges is actually worth it, given that Manhattan and New York City in general has rising crime rates, that there's a lot of demand for prosecutors to do something about that. And so he kind of knew that he was trading some of that time and energy that might be used on those issues on the time and energy associated with that. So I'm sure he took that into consideration. He also must have taken case factors into consideration. I mean, if you followed any of the coverage following the announcement of the charges, there's some concern about, well, has too much time passed? It's 2016. It looks like, from what I've read, the statute of limitations were waived in many cases in New York due to COVID. So Bragg's is probably pretty safe on that. There's also, for these charges of business, falsifying business records are usually misdemeanors, but to be felonies, they have to be linked to the furtherance of another crime. And so there's some concern about whether or not that furtherance of another crime, like just how solid that evidence is. And when you think about the unwillingness of the charged, the defendant to cooperate, there's probably no chance he's going to take a plea. And when you think about key witnesses like Michael Cohen, might not be a good reason to pursue. And another thing is just the fact that this is a former president, right? This has never happened before. No other sitting or former president has ever been charged with a crime. So clearly he took all of that into consideration as well. So what is the factor that he considered? Well, I think it's fair to say that the political factors were in mind. And in this way, I'm not making a case of, like, you keep hearing, oh, he's a George Soros elected, he's in the pocket of big billionaire George Soros, which that claim has these sort of anti-Semitic trope issues with them. You hear that, but I don't think that's, in my opinion, what's going on. But this is just my opinion. I think what's going on is that Alvin Bragg sees himself as a reform-minded DA. He was elected because he said he wanted to reform the criminal justice system. And I think with that in mind, he is, as he thinks about how many people are charged with crimes and charged heavily with crimes and then end up a lot of time in the criminal justice system, he's probably thinking about that those penalties and those charges generally fall on those people within our society that have sort of the least means, right? And that it's sort of, the balances are sort of skewed perhaps to charging and prosecuting crimes against those who have a lower standing within our society. And so I think as a reform-minded district attorney, knowing that people don't always have the best counsel, that end up maybe pleading guilty when in fact they're not guilty, it wouldn't surprise me if he thought that on the flip side of that there are people with means and a lot of money and often can work the court system to get out of being held responsible for criminal activities that they have potentially engaged in. And I think that as a reform-minded DA, he must have really considered that no one is above the law. And he also might think that living in Manhattan, which is a very liberal city, he might think that that's what the people who elected him wanted. Somebody to go after President Trump because they might think that he hasn't been held accountable up to this point in his life. So it's hard. I mean, I think that there are good cases to be made that charges shouldn't have been pursued. They were pursued, and we'll see how this plays out. Although the next court appearance isn't until December, so we won't know for quite some time. All right, this brings us to the other court personnel that we're going to discuss, which is the defense attorneys. And so both defense attorneys are not DAs, okay? I know some people are like, defense attorney, DA. They're not. They're just called defense attorneys, okay, or public defenders. So both defense attorneys and prosecutors are officers of the court, no doubt. They make up part of the courtroom work group, but clearly they have different focuses. The prosecutor enforces the law. They represent the state against those who are accused of crime. But the prosecutor also needs to seek justice, okay? That is their goal, that they are working in pursuit of justice. And that means they cannot knowingly falsely charge somebody. If they know somebody hasn't committed a crime, they cannot falsely charge them with the crime because that is against the pursuit of justice. Same with it, they cannot try that individual. And also, if there's any evidence that says that this person is absolutely not responsible for this crime, that's what's known as exculpatory evidence, they have a professional duty to turn that over to the court and to the defense attorney. So if they come upon exculpatory evidence, they basically have to say, I've got to drop the charges. The focus of the defense attorney is very different. The focus of the defense attorney is not necessarily on justice, but defense attorneys are obligated to provide the best defense possible for the criminally accused. That is their job. And in the process, they may very well face conflicts between law and ethics, right? That they may not put somebody on the stand because they know that it might harm their client's chances. They may not put their client on the stand because they know that it might harm their clients. And so you can read more about some of these conflicts between law and ethics that the defense attorneys face. But at the end of the day, what defense attorneys do is they have a professional obligation to provide the best defense possible for the criminally accused. The duties of the defense attorney are very similar to the duties of the prosecutor. They investigate the incident. And so obviously, one of the big differences is that prosecutors, decide whether or not they should charge somebody with the crime. Defense attorneys get involved after somebody's been charged with the crime, obviously, because they need defense. And so once somebody's been charged with the crime, then they are there to, help their client. They represent them at pretrial procedures, such as they represent them at the arrest. You have a right to counsel at the point of arrest, at interrogation, and at the lineup, and during the arraignment, right? And so that the defense attorney is involved in, really a lot of those pretrial activities. And as you'll see in the documentary you're watching this week for extra credit, that's what a lot of time is taken up with. They also investigate the incident as they are preparing for both pretrial and trial preparation. If there's a plea of guilty, then they will participate in the plea negotiations with the prosecutor. If there is no guilty plea, they'll prepare for trial and they'll represent their client at the trial. They provide the assistance at sentencing if their client is found guilty, and that they will determine the appropriate basis for an appeal. And so that, in summary, is the duties of the defense attorney. So the Sixth Amendment of the United States Constitution tells us that nobody can be denied the right to counsel. If you want to have a counsel to defend you in a criminal case, you have that right. You can choose not to exercise your Sixth Amendment right to counsel, as was the case most recently with the defendant in the Waukesha holiday parade murder. But most people exercise their right to counsel. There are different ways, and we'll be going into the Sixth Amendment and trial rights and the right to counsel in more detail in a week or so. But the criminally accused have two options for criminal defense. Okay, one option is that if the court system determines that they have enough money to provide for their own counsel, then they get a private attorney, right? And so if you're deemed able to afford an attorney, then you go out and you hire a defense attorney from the private bar. If the court determines that you are indigent, that is unable to afford an attorney, then it's the state's obligation to provide that attorney because of the Sixth Amendment right to counsel. Nobody can be denied the right to counsel, even if you are too poor to afford it. And so let's take a look at different ways that the state provides for criminal defense. So there are three major systems for assigning defense, and I'm just going to go ahead and put these up here all at the same time, and then we'll just talk through these. Probably the main way of assigning defense for those who can't afford an attorney is through what's known as the public defender's office. And so that a public defender is basically a public law firm whose only clients are criminal offenders, okay? And so, like, if you're a prosecutor, you work for the state of Wisconsin, right? The state of Wisconsin pays your salary, and it pays the assistant, attorney general's or district attorney's salaries as well. A public defender is a state employee, and that they are paid through state dollars to provide defense for those who can't afford it, because the state has an obligation to provide that. And so the public defender in Wisconsin, it's the Wisconsin State Public Defenders, that is a law firm that is administered by the state. The federal government has federal public defenders as well, and a lot of people who are accused of crimes use public defenders. According to the Bureau of Justice Statistics, about 42% of state level criminal defendants who are charged with a felony use a public defender. And in federal criminal cases, it's about 62% of the defendants who are represented by a public defender. So it is probably the main way that we provide criminal defense in the United States. There's also the assigned counsel method and the contract blocked system. The assigned counsel is that you have a group of private attorneys who get like on a list, and then as somebody comes to a court and doesn't have means to pay for the attorney, then the private attorney that is on the list will be appointed to that case. And you'll read more about that in the textbook. A contract system is where a block grant, a grant of money is given to a private firm, and then they are obligated to, under that contract period, provide criminal defense for those who can't afford it. So read more deeply about those in your textbook to get an idea of sort of the pros and cons of these different systems for assigning defense for those who cannot afford it. So this week you have an extra credit opportunity. Here we are getting near the end of the semester. You might be hungry for some extra credit points. And here is a fun and really, I think, very compelling way to earn these extra credit points. So the extra credit points, it's an online discussion that you engage in and that you watch Gideon's Army, okay? And Gideon's Army is this excellent documentary that follows the personal stories of 3 public defenders in the Deep South of the United States. And so when it comes to public defense, it's difficult throughout the United States. It's extraordinarily difficult in the southern parts of the United States. And so the reason that it's called Gideon's Army is because it's the case Gideon versus Wainwright from 1963 that extends the right to counsel to all criminal defendants. And so it shows just this great life stories of Travis Williams, Brandy Alexander, and June Hardwick, and the challenges that they face being public defenders, but also how important it is that we have public defenders who are great at their job, because to live in a democracy means that everybody deserves a vibrant defense. Because if the state is able to convict people and they don't have proper defense, that basically makes a mockery of justice. And so you'll see in this documentary how how hard these people fight to make sure that everybody gets a good criminal defense. Well, that's it for me. Thank you for paying attention. I know this is a little bit longer than I wanted it to be, but there was a lot to cover. So thanks for paying attention. I appreciate it, and I'll talk to you again soon.